Bricc Baby, the brick, not the trick. Man, don't see late. God dang, the feds say they want 92 to 115 months. We're going to dig deep into this one. So let's really get into this one right here. Y'all know we got Bricc Baby right here, and y'all see the sentencing memorandum right here in date. That's going to be at 9 o'clock, December 19th, 2025. And yeah, plaintiff, United States of America, by and through its counsel of record, first assistant United States attorney for the Central District of California, assistant United States attorneys Kevin J. Butler and Jenna McAbee. Anyways, yeah, the sentencing memorandum is based upon the attached memorandum appointed authorities, the files and records in this case, and such further evidence and argument as the court may permit, dated December 5th, respectfully submitted, Todd Blanche, Deputy Attorney General, and Bilal Esley. Look how they just put his ass all the way up under there. First assistant United States attorney. Don't worry, we got another little dirt video that's about to set the damn internet on fire tonight. So make sure y'all got y'all bells on. And then y'all can see all of this shit. Memorandum of Appointed Authorities. Introduction. Defendant Zihirr Mitchell, defendant, has pleaded guilty to being a felon in possession of firearms and ammunition seized from his home in 2023 and admitted to being a felon in possession of more ammunition he fired at others in a parking lot in 2022, as well as submitting a fraudulent application for disaster relief based on the January 2025 fires. For his crimes, the United States Probation and Pretrial Services Office, the USPO, calculated a total offense level of 23 and a criminal history category of 6, resulting in a sentencing guidelines range of 92 months to 115 months imprisonment. Pre-tense investigation report PSR 139, docket number 31. The USPO further found no bias for departure or variance from that range. The government agrees and respectfully recommends that defendant be sentenced to 92 months imprisonment, 3 years supervised release, no fine, and a $100 special assessment. Bricc, you was trying to hit the Palisades and Eaton fires for their money too? And this be the real when y'all be hearing people complain about the expediency of money just given out, this be the reason. Cats see stuff like that and go, I wonder how I can get one. The most common one that we know that's widely accepted is the PPP loans. So there's that. But goddamn, Bricc, huh? It gets worse. Roll it. Defendant's crimes. Over multiple months in 2023, law enforcement intercepted defendant on a wiretap of multiple rolling 60 gang members' phones. On multiple intercepted calls, defendant was heard discussing criminal activity, including recounting murders he committed as a youth. In March and June 2023, on intercepted calls, multiple people accused defendant of pointing a gun at them and even defendant's own daughter. I think they're talking about his baby mama. Law enforcement then sought a search warrant for defendant's home, where they found 3 firearms, including an assault rifle-style firearm and over 125 rounds of ammunition. Law enforcement also learned that defendant shot 3 bullets in a business parking lot in July of 2022 to ward off would-be robbers. They found another firearm and even more ammunition when they arrested him on those charges in March 2025. Each possession followed multiple prior felony convictions, any of which alone prohibited him from possessing any firearm or ammunition. Not to mention the dangerousness and unlawful ways he was using the firearms, even if he was permitted to possess them. Separate and apart from defendant's unlawful possession of firearms and ammunition, in February 2025, defendant filed an application for disaster assistance, knowingly and falsely claiming that defendant was renting a home in Pasadena, California, that was destroyed by the Eaton fire. By doing so, defendant attempted to receive Federal Emergency Management Agency FEMA benefits. Defendant knew, however, that he never lived in or rented a home in Pasadena and was not a victim of the Eaton wildfire, which was declared a federal disaster, and was not entitled to any of the benefits or funds he sought in filing the false application. When the genuine homeowner and victim of the disaster applied for a loan, it was denied due to defendant's pending false application. Damn, that's cold. And that's one of the reasons why I'm so annoyed with people. And I always say you get what you deserve when you do shit like that, bro. Because there is no victimless crimes when you cats is out here scamming. You guys are using somebody's money. Whose money? We don't know. So now we find out, bro, you filed a bad application And there were people waiting on that money who was actually affected. Bruh, you could have just made up if you're going to do this, you might as well make up a false damn address. Bare minimum. So that nobody is affected. This be that shit where it's like, bad habit upon bad habit. It is what it is. You get what you get. I don't wish him, the maximum sense and all this shit, but I'm damn sure not about to be like, damn, bruh, this is worth laughing at, because it's not. That shit, bruh, nah, I ain't feeling that one, bruh. But shit, when y'all try to scam and try to run up your money, and trust me, I know better than most how expensive LA is. But at that same damn time, bruh, nah, I can't rock with this one. But let's continue on. Guidelines calculations. The USPO and government agree that the base offense level for each count in the indictment is 20 under USSG 2K2 IA 4A because the defendant had been convicted of a crime of violence before committing each of those crimes. We just go through penal codes. To commit a crime which will result in death or great bodily injury to another person. Then it says a conviction under California Penal Code sections 422 and 664 is categorically a crime of violence. For count 2, the USPO and parties agree that a 2-level increase under USSG 2K2 1B1A applies because defendant possessed 3 firearms. For count 1, pseudo count 2A in the PSR and USPO and parties agree that a level 4 increase under USSG 2K2 1B7B applies because defendant possessed the ammunition in connection with another felony offense, namely shooting at people from a parking lot. Finally, for defendants' fraud in connection with a major disaster and emergency benefits, i.e. pseudo counts 2B and the PSR and USPO and parties agree to all the calculations. Specifically, the base offense level is 7 under USSG 2B1 1A1, and the resulting offense level is increased to 12 under USSG 2B1 1B 12 because the offense involved disaster fraud. Plea agreement 12. The highest total offense level of the foregoing counts is 24, which receives a 2-level increase for multiple counts. The USPO and government agree that a 3-level reduction for acceptance of responsibility applies under USSG 3E 1.1 ID 59 through 60. Thus, the total offense level is 23. The USPO and government agrees that defendant is in criminal history category 6. With the foregoing calculations, defendant's guidelines range is 92 to 115 months. We're already suggesting that he does 7 years, 8 months, or 9 years and 7 months. That's insane. That is 100% insane from a good way, because they damn near were trying to hit his ass with an enhancement, which would have been a mandatory 15. I got into an argument with a blogger. They ain't gonna bring this shit up because I spanked them in this argument. And I told them, there are so many programs that the feds give you and reduction and all of this shit. Bruh, hell no. He's not gonna get that 15. And they kept telling me, you don't know what you're talking about. Bruh, you ever went to the feds? No, I got homies who been to the feds. I don't care. You been in the feds? No. You ain't been in the feds either. You're damn right. But you know who I have that you don't? Federal lawyers. See, everybody wants to be intelligent and articulate and talk about their experiences and all of this shit. When in all candor, all you need to do is listen to the lawyers. They don't give a damn about because you got caught that make you an expert. No, it doesn't. It means your ass had to accept something and you only understood it for you. But I ain't gonna hold you, bruh. Some of y'all probably like, Nash, you done sidestepped the hell out of that damn accusation that he said he got bodies. Man, that nigga's on the phone talking, bruh. That wasn't real. Because remember, murder has no statute of limitations. It don't matter when you did it. And I think they ultimately caught his ass from shooting them bullets because he was doing this. He probably, I was excited on that damn hobbies, and that nigga shot that robbing in that parking lot. Damn hobby, nigga, I have to bow. I was sounding like Ceddy Nash, nigga, on that news network in Sacramento. I was sick, so I was like, boom, like Ceddy Nash. Yeah, bro. I think that's how they caught him for that shooting, for that one. But let's continue on. Government's recommendation: imprisonment. The court must impose a sentence that is sufficient but not greater than necessary to achieve the purpose set forth in 18 U.S.C. 3553A. The court shall consider the nature and circumstances of the offense and the history and characteristics of the defendant, 18 U.S.C. 3553A1. In addition, the court should fashion a sentence that reflects the seriousness of the offense, promotes respect for the rule of law, provides just punishment for the offense, affords adequate deterrence to criminal conduct, and protects the public from future crimes of the defendant. Among other considerations, 18 U.S.C. 3553A2. The government recommends that defendant be sentenced to 92 months imprisonment, which is the low end of the guidelines range. Such a sentence is sufficient, but not greater than necessary to achieve the purpose set forth in 18 U.S.C. 3553A. Nature and circumstances of the offense. The court must consider the nature, circumstances, and seriousness of the offenses. Here, the government's proposed sentence reflects the seriousness of defendant's crimes. In this case alone, defendant possessed multiple firearms on multiple occasions and over 125 rounds of ammunition, some of which he fired. First, defendant shot at would-be robbers in a business parking lot. Less than a year later, he was found with more firearms after purportedly pointing them at his partner and child. Now, that's not saying that he admitted it, but like I said in the beginning, we read this in the indictment. His BM said that happened. Each time, defendant was prohibited from even possessing firearms and ammunition, let alone so dangerously using them. Defendant then possessed yet another firearm the night before his arrest during a live stream podcast with one of his rivals, and the gun can be seen in defendant's waistband. His possession of that firearm the following day, along with even more ammunition at home with his child during his latest arrest, only further corroborates the need for a significant sentence. The defendant's crimes do not pertain only to violence and weapon possession. In his plea agreement, defendant admitted to fraudulently applying for Fema benefits by claiming to be a renter of a Pasadena home that was destroyed in the Eaton fire in January 2020. Because of defendant's false application, the homeowner who really lost his home had his own loan application denied. Wow. Defendant's crimes have consequences, first for his victims and for now himself. This is why the government is seeking a 92-month sentence. 2, history and characteristics of defendant. And I always say that word, bro. Like, y'all history be killing y'all, but we always say it this way. History and characteristics. Defendant's history and characteristics also warrant a 92-month sentence. Defendant's criminal history is decades long. His first felon in possession firearm offense specifically dates back to 2009. His probation violations began no later than 2012. By 2014, he threatened a crime with intent to terrorize his victim, received a stay-away order, and blew through the court's leniency with multiple probation revocations, much like his attitude encapsulated in wiretap calls in this case and on video podcasts. As late as this year, back in 2016, he assaulted victims with a deadly weapon when he lifted his shirt to brandish his firearm, saying, "Don't fuck with me." Even his 6-year prison sentence for robbery in 2020 did not dissuade defendant from committing all the crimes in this case. All of that, which is only a fraction of defendant's criminal history, surpassing the points needed to be the highest criminal history category, and include a high-speed chase ending with defendant barricading himself inside a home on television, which defendant later glamorized in music videos, warrants the government's recommended sentence. Need for deterrence and to promote respect for law enforcement. The recommended 92-month sentence is necessary not only to deter defendant, but also to adequately deter others. Bullshit. The sentence imposed is required to afford adequate deterrence to criminal conduct, which encompasses both specific and general deterrence. This 92-month term from imprisonment is warranted here to adequately deter defendant and others from further criminal conduct. It is longer than past sentences he has received for a good reason. Defendant's past sentences were too lenient to promote his respect for the law. What they really trying to say is, you showed your ass. They trying to say, we had a pleading heart for you. They trying to say, bro, we was rooting for you. We rooted for you. And, yeah, you ain't adhered to none of this shit. So, Mr. Zihirr Mitchell, you got to sit it down for the long haul, buddy boy, because we already out of chances and F's to give. Once you smack our hands when we try to offer you nothing but basically consequences of your actions, hell nah. You want to know what's crazy about a whole lot of this shit? Had people just decided to Sign on a dotted line to get legal firearm, a lot of this shit wouldn't even exist. If Bricc would have literally owned firearms legally, a lot of this shit wouldn't even exist, bro. But I get it. Speeding, fast life. It is what it is. Let's wrap this up. Supervised release. Given the seriousness of the instant offenses, the imposition of a 3-year term of supervised release will provide a needed additional incentive for a defendant to refrain from committing further crimes. In this case alone, defendant admitted to 3 separate crimes during 3 separate years, starting with a shooting and ending with a disaster fraud. His criminal history, which landed him in the highest criminal history category, is riddled with prior probation violations. A 3-year term of supervised release is sufficient, but not greater than necessary to protect the public and deter future criminal conduct. Conclusion. Defendant and his conduct are full of contradictions. God damn. Defendant purports to be a dedicated father and indeed appeared to be present caregiver for his youngest child. Defendant also kept illegal loaded dangerous firearms and her presence in multiple residences unsecured. Defendant is also a charismatic and talented public figure, but thus far the defendant has used his gifts merely to glamorize violence, drug use, and a life of crime, and has been unable or unwilling to transition fully from that life to a productive one. It is these contradictions that demand a guideline sentence, but one at the low end of those guidelines. Thus, the government respectfully recommends that defendant be sentenced to 92 months imprisonment, 3 years supervised release, no fine, and $100 special assessment. So, one thing that we often do a lot of times is we try to understand, right? And it's unfortunate that people just don't want or can't, right? You're either in a problem, headed towards a problem, or coming out of one, right? And he ain't know nothing. And you would think, right, that you would have a mindset of adaptability, but awareness more than ever to believe that your ass was about to leave Georgia, come to California, become known, and just had these random ass conversations, bro. You wasn't thinking, man. And this ain't no slight at Bricc. This is really just me being in a level of disappointment, because I know there's going to be bloggers who flip this and go, you're dissing Bricc, but y'all know each other. Man, shut up. What I'm saying is simply this. We can't really feel bad for Bricc like that. As much as we want to, you have to have a level of know, K-N-O-W. You just have to know. But I'm more curious as to what his lawyers are going to file and basically come back with, because they're going to have to try to argue him down for 5 years. And whatever they write better be damn good, because we ain't seeing nothing about no plea. So you can't say, well, we helped secure this victory. He told on this, he told on that. None of that shit exists. So what y'all gonna point to? That he accepted shit? That he stopped wasting taxpayers' money? But I hope these lawyers got something, because if they don't, shit, I might have to come up with something my damn self. Maybe I should have did in this video. Do y'all want that? Do y'all want me to kind of possibly take it a step further and suggest laws that they could use? So hold on, here we go. What they could charge, well, what they could fight with would be multiple firearms enhancements, and then the ammo with another felony enhancement. So they basically would be fighting enhancements. Then you're looking at the downward departures, talking about circumstances not taken into the account, the 5K 2.0. So basically, even the whole entire thing with the shooting and all of that stuff within the parking lot, like, where's the evidence exactly? It's only really him. They say it's on video, but what bullets were used? They never specifically said they picked up shell cases and all that. It sounds real ASAP Rally-ish. And then they can say the criminal history is too high. It's for a 1.3, and then they can go for, which they always do, is going to say his mental health, right? Because you can make a case, bruh, I can't really have no damn firearms, but people try to rob me, bruh. What was I supposed to do? Get robbed? So if y'all can use that to have it go against me, then shit, it is what it is. So basically, and this is what we said in the beginning, boy, if I nail this one, I might have to go get that bar. Because what we said was he gonna get like 5 years. We say he gonna get 60 months. No pun intended. Like 60 to 72 months. So we shall see. Man, I'm rooting for the best for him. But honestly, bruh, it's the feds. You done already pleaded out, bro. All of that shit y'all always say when y'all locked up with the most positive spirit, bruh. I'm just hoping the most positive spirit on your sentencing, and we'll see exactly what happens. Sure to keep your people aware, subscribe, turn on bells to notify. Click right here for the playlist, and I'll catch y'all in the next one. Remember, we're giving these away, so don't go nowhere. Keep that bell locked on. We'll have a major Lil Durk video dropping soon. I'll catch y'all in the next one.